Today, I would like to speak about the importance of funding your living trust, what it means to fund a trust, and why it's important. Once your trust has been created, it has been signed, and the tax ID number was obtained, if applicable, your trust is like a box, like an empty vessel that needs to be filled with all the things which you want to protect. Why is it important? Why are we talking about funding at all? Because your plan is only effective to the extent it was implemented, and if you don't transfer your assets to the trust, your assets are not protected. We will typically have the conversation with our clients about which assets should go into the trust, where the trust must be designated as a beneficiary, and which assets they should keep outside the trust. In practice, transferring something to a living trust is very easy. All you have to do is to change the name of who owns the asset. For example, if John Doe has an investment account, to transfer that account to his trust, the name on the account needs to be changed to the Doe Family Trust, if that's the name of the trust. Sometimes the name would appear as the name of the trustee, comma, the name of the trust. That's because the trust can only act through its trustee, and usually the name of the currently acting trustee will appear on the statements and other documents related to the account. To transfer your home or any other real property into your trust, you need to sign a deed, typically a quitclaim deed from you personally to your trust, or rather to the trustee of your trust. A deed could be prepared and signed at the same time when you sign your trust and other estate planning documents, or it could be done later. Once your home is in the trust, do not forget to notify your homeowners or property insurance carrier. That's very important, so they can update the name of who owns the property and add the trust as an insured. For financial accounts, to transfer financial accounts into your trust is very easy. All you need to do is to call your bank or your financial planner and request to retitle your accounts in the name of your trust. They should be able to prepare a simple form for you to sign, and once submitted to the institution, to the financial institution, they will transfer the account from your name to the name of your trust to your trust. Any financial accounts, annuities, insurance policies, anything that can be transferred or is assignable can be moved into a trust. In other words, any asset that you can give to your spouse or to your child, you should be able to transfer to your trust without any difficulty. You must always consult with your attorney which assets should go into your trust and which assets should not. And we would always have the conversation with our clients and their financial advisors as a part of our planning process. For some assets, you may only need to designate the trust as an on-death beneficiary. Why not to transfer? Well, there might be different reasons. The asset may already be protected during your life, or there might be tax reasons to keep the asset in your name as opposed to placing it in a trust. Whatever the reason is, you may still designate your trust as an on-death beneficiary, so that the asset will be added to the trust property after you or you and your spouse pass. Again, to make that kind of designation, all you need to do is to contact your bank or financial planner and request to change the beneficiary designation. They will be able to prepare a simple form, and once the form is signed and submitted to the financial institution, they will make the change. It's very important to keep your plan consistent. The way your assets are titled during your life, as well as beneficiary designations, will have effect on how well your assets are protected. There may also be tax consequences which you need to consider. Keep in mind that even the best estate plan is only effective to the extent it's implemented. And for a living trust, it means to the extent your trust is funded.
Milvitsky Law Group is a full-service elder law and estate planning law firm with 4 offices located in Paramus, Morristown, Jersey City, and Red Bank. We serve communities throughout New Jersey and New York. Call us at 201-380-2000 or visit us online at www.thelawofaging.com. Make sure that you subscribe to our newsletter to stay up to date on important developments in estate planning and elder law.